Now, the Communications Authority of Kenya has rejected proposed changes to the Kenya Information and Communications Act, claiming they would discourage investors in the information communication technology sector. Now, the authority's Director General Francis Wangusi shocked members of the National Assembly's Committee on Information when he said the changes may have been sneaked in the statute Law Bill 2015, currently before the House by shadowy individuals keen to usurp the authority's mandate, since the Information Minister and the Attorney General have denied knowledge of the amendments. Now, the Communications Authority is charged with the responsibility of protecting and safeguarding the interests of consumers in relation to the provision of ICT services and equipment, as well as reviewing the regulations on SIM card registration.
Suppose one is dominant. What are the kind of rules that we are going to apply to that player in order not that player abuse that kind of dominance in that market? And should that player abuse that dominance, what kind of penalties can we be able to give? And this is the process that we are going through. So we find that there might be certain forces elsewhere that are trying to skew the law in order to derail us from this trajectory, which we believe at the Communications Authority of Kenya is the best way to regulate the market. We feel that the amendment bill, in our view, is going, first of all, to weaken our powers, and secondly, if it is allowed to pass, it is going to erode the gains this honorable country has achieved so far. It is also going to give us a negative publicity in terms of the countries that have respected Kenya as one of the model regulators in Africa. And furthermore, then, it is going to very seriously reduce the contribution of the ICT sector to the GDP. We are also worried that this might lead to not only discouraging investors, but also facing a situation like what we had with you, where some of the investors would want to pack up and go. When we conferred with the Minister for Information and Communications Technology on this particular matter, he vehemently denied that he was ever party to this. He was not consulted, and he also was taken aback just to see it coming in the miscellaneous amendment bill. So we don't know the source of this.
Your authority is envisaged to be an independent authority.
Yes.
What is the import of these particular amendments in this bill with respect to your independence?
That sentence is very important. And it is actually the peak of the whole bill, that the body shall be independent of any commercial, political, or government interest. And the reason for that is because of the very nature of this industry that we are dealing with. So to make this amendment, where we are taking it back to the ministry and to the government, is actually going totally back to square one. And therefore what it means is that there are certain bodies which will not fall under CA to be regulated. Those bodies will now do what they want because they will no longer be regulated by CA. So it's actually a very, very serious matter.
When the Attorney General who drafts feigns ignorance, the Minister feigns ignorance, then surely it wouldn't be wrong to call this document illegitimate. Illegitimate because the normal originators of such documents have disowned them.